The former president of the Senate, Stanley Felix, was facing the possibility of a 5-year jail term for the offense of perverting the course of justice. The charge emanating from visits on April 21st and April 24th, 2022 to a client who was detained at the ancillary police station for murder. The allegation was that Felix acted to conceal the murder committed by his client. On Wednesday, 20th March, the High Court in Castries dismissed the case against Felix. Speaking at a press conference on Thursday, 21st March, Felix questioned the motive for charging him.
I was charged with perverting the course of justice under a section of the law, section 376 of our criminal code. And essentially what the judge said was that what was presented to her did not suit the particular section. In essence, she used the words entrapment based on what was presented to her.
Felix was charged under Section 376 of the Revised Criminal Code of St. Lucia of 2005. He says his client was a suspect and not a witness at the time he was alleged to have committed the offense.
Would not have taken the most brilliant of lawyers to realize that the provision of the Section 376 makes it mandatory that to pervert the course of justice there must be some kind of interference with a witness in a case. In my case, there is no witness. Maybe it was the intention to make this person a witness, but at the time when I visited this individual as his representative, he was not a witness. He was a suspect in custody, which all of us lawyers do from time to time.
Felix was represented by attorneys Lon Theophilus and Alberton Richlow. Richlow says he remained focused on the criminal code as it pertains to the charge against his client.
My role in this whole thing was to ensure the due process was observed. At the time that I was retained, I looked at the file, I prepared some voluminous submissions. Because of course, I must tell you that there's a slight difference between the law of St. Lucia when it comes to the question of the interference with witnesses and the law of England. More primarily, it's because we in St. Lucia, we have what is called a criminal code. And so therefore, we can only go along with the language of the code and nothing else.
The now visible Felix says the whole ordeal weighed heavily on him from the start.
It was just not to tarnish my reputation. The resultant effect was reputational damage. But I believe that I was in the right position, occupying the right position as president of the Senate. And so the impact of arresting and charging the president of the Senate would be quite damaging or embarrassing for a sitting government. And so I was that target. And a group of individuals coordinated the entire thing and resulted in my arrest.
The former housing minister and former president of the Senate says he's not given serious consideration to his next course of action in this matter. This case has raised questions of how far is too far for a defense attorney in representing his client, the issue of attorney-client privilege, the laws of England and Wales versus the laws of St. Lucia, which one applies and when, and ensuring the correct charge has been laid for an alleged offense. Stanley Felix for the HCS News Force.